Allodium, land freely held, without obligation of service to any overlord. Allodial land tenure was of particular significance in Western Europe during the Middle Ages, when most land was held by feudal tenure. At the end of the 9th century, the extent of allodial land in France was increased by the anarchy that accompanied the decline of the Carolingian monarchy. Much of this new property, however, was eventually brought into a feudal relationship in which the holder owed certain services to his lord. By the 12th and 13th centuries, the only appreciable amount of allodial land remaining was limited to peasant holdings in the southwest. In Germany, large allodial estates held by nobles continued to exist, particularly in Saxony. Guidepost https://www.britannica.com/topic/allodium. In England there was a considerable amount of allodial land before the Norman conquest 1066, but it disappeared under the new rulers. Allodial land, though free of limitations from above, was not free of restrictions from below if the holder chose to have feudal tenants. He would then owe certain obligations to them, primarily in terms of protection, and could not be considered in absolute control of his holdings. With the decline of feudalism in France, land that had been under the jurisdiction of a lord came to be under the jurisdiction of the king, who collected certain fees upon its sale or transfer. Following the French Revolution 1789, all land became allodial. In England no land is referred to as allodial, but an estate in fee simple corresponds in practice to absolute ownership. Allodial title law and legal definition. Allodial title is a real property ownership system where the real property is owed free and clear of any superior landlord. In this case, the owner will have an absolute title over his or her property. Property owned under allodial title is referred as allodial land. Allodial lands are the absolute property of their owner, and are not subject to any service or acknowledgement to a superior. In allodial lands there will not be any control by a superior landlord. Guidepost https://definitions.uslegal.com/closing parenthesis. An individual's allodial title is alienable in nature. Alienation can be done in the form of gift, mortgage, or it may be distressed and restrained for collection of taxes. The allodial nature of a property will be lost when the property is transferred to more than one person. Therefore, to retain the allodial title he can transfer his or her property to another single individual. For example, when an owner of a property dies leaving ownership to more than one heir, the allodial status of the property is lost. The following is an example of a case defining allodial title. Allodial title is defined as one that is free. Stewart v. Chicago Title Inns. Co. 151 Ill. App. 3D 888 Ill. App. Court 1987. 381.020 Titles allodial and subject to escheat, right of eminent domain. All land titles in this state are allodial, and, subject to escheat, the entire and absolute property in all land in this state is vested in the owners, according to the nature of their respective estates, except that the Commonwealth retains the right of eminent domain in and to all real estate. Effective. October 1, 1942. History. Recodified 1942 KY Acts Ch 208, Sec. 1, effective October 1, 1942, from KY Stat. Sec. 2338. Escheatment process accounts, abandoned or unclaimed. The escheatment process. All states require financial institutions, including brokerage firms, to report when personal property has been abandoned or unclaimed after a period of time specified by state law, often 5 years. Before a brokerage account can be considered abandoned or unclaimed, the firm must make a diligent effort to try to locate the account owner. If the firm is unable to do so, and the account has remained inactive for the period of time specified by state law, the firm must report the account to the state where the account is held. The state then claims the account through a process called escheatment, whereby the state becomes the owner of the account. As part of the escheatment process, the state will hold the account as a bookkeeping entry, against which the former account owner may make a claim. States tend to sell the securities in escheated accounts and treat the proceeds as state funds. When a former account owner makes a valid request, however, the states will normally provide the former owner with cash equaling the value of the account at the time of escheatment. This amount of cash does not include any dividends or interest covering the time after escheatment. There are several websites, including commercial ones, where you can search for unclaimed property. One non-commercial site, the National Association of Unclaimed Property Administrators, allows you to search by individual, state. States have their own requirements for finding and claiming unclaimed property. If you believe you have unclaimed property, the state will require you to send them information about yourself to verify your ownership of the unclaimed property. After verifying your ownership, the state will either mail you a claim form or permit you to fill out the form online and print it for submission to the state. Guidepost. Sec.gov. Also you can refer to Black's Law Dictionary 4th edition. Allodial. Free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. Barker v. Dayton, 28 Wis. 384. Wallace v. Harmstad, 44. Pa 499. Allodium. Land held absolutely in one's own right, and not of any lord or superior, land not subject to feudal duties or burdens. An estate held by absolute ownership, without recognizing any superior to whom any duty is due on account thereof. 1 Wash. Real Prop 16. McCarty v. Orphan Asylum, 9. Cow, NY, 511, 18 MDEC.516. The end. Always remember to your own due diligence, as I am only a guidepost to knowledge. Codes and laws change every day. Get your own over and understanding. Read, apply, execute.